I would now like to introduce today's speaker, Jim Cunningham. Jim is the CEO of Cunningham Legal, an estate planning and trust administration law firm with 7 offices around California. Jim is certified by the State Bar of California as a specialist in estate planning, trust, and probate law. He's licensed by the state of California as a real estate broker and licensed by the state of California as an insurance agent. Today, Jim is going to review the common areas that require funding and how to fix and fund each properly. With that, I will hand things over to you, Jim.
Well, Jennifer, thank you so much for that wonderful introduction. Today, we're going to cover 8 areas that I recommend you pay attention to in funding your trust. Now, when I say funding your trust, I'm going to break that down as we go through the materials. These are areas that we see in our practice over and over and over again, the same mistakes made over and over again. So hopefully, after you've listened to this, you're not going to make those mistakes, right? That's the plan. That's the idea. And we're also going to go through the steps on how to fix them. So we're going to identify this is a problem area, and this is one way of fixing that. Before we get too far into this, the State Bar of California requires that when any lawyer speaks, and I'm a lawyer licensed by the State Bar of California to practice law, that we tell you, if you're listening and tuning into this, that this is information only. This is not legal advice. Legal advice is one-on-one with a lawyer, where the lawyer interacts with you for your own personal situation. So this is information only. So please don't take what we do here and go do stuff on your own. That can really be not good and is not really the point of this. The point of this is to educate you on the topics. So we're going to start with trust funding. So what is trust funding? Well, what's a trust? A living trust is what we're talking about here. So there's a whole bunch of other trusts that we're not really talking about, but for our purposes today, we're going to talk about the normal revocable living trust that you might create for you and your family. Funding a trust, what that means is you can think of a trust as a bucket. So a bucket, when it's made, is empty. There's nothing in the world. There's air in the bucket, right? And if you create this trust, this bucket, funding is the process where you transfer assets from your own name, think of them being in your own hands, into the name of the trust. So you take your bank account, your stocks, your bonds, your real estate, and you take those from your own personal name into the name of the trust. And actually what it says, Jennifer, is it says, Jim, trustee of Jim's trust. And that's how title is taken. That's how you fund the trust. That's how you put assets into the bucket.
Thanks, Jim. Since we're going to talk about probate, this is a good time to launch our first poll. The question is, have you or someone you know gone through a formal court probate? The choices are yes or no. Please take the next 15 seconds to make your selection, and then we'll share the results. Okay, it looks like most of you have responded. We'll close out the polls in a few seconds. Okay, let's go ahead and share those results, and it looks like most of you have said no. That's great, actually.
Yeah, that's a really good thing. So what we're going to do is we're going to talk about this within the context of a story. So we're going to talk about Judy. Now, this is not a client. So this is a hypothetical, as we say in law school. So we're going to walk through the 8 mistakes that Judy makes in the funding of her trust. And then we're going to talk about how to avoid those. So we have Judy here. Judy's husband has passed away, and she had what we call a very good estate plan, right? So it's an estate plan that was well written by an expert lawyer. And I will tell you guys, for those of you listening, you do not want to go to a generalist when you do estate planning. You want to go to an expert. What's happened in the legal field is much like the medical field, is everyone's a specialist. It's getting so granular. It's an inch wide and a mile deep. So Judy did go to a specialist, has very good estate planning documents, and then she passes away. And her son comes in to see us. And so what we'll be talking about is all the things that Judy didn't do and that now her son has to deal with. So he comes in to our office to ask for help. And the term I used before is trust funding. That's part of the story. What we're going to talk about is retitling of assets and alignment of the assets with Judy's estate plan. And you'll see as we go through the examples, these weren't exactly aligned with her estate plan.
I know we're jumping in and doing two polls back to back, but these are great questions and give us a lot of insight. So we're going to launch poll number 2. The question is, if you own a home, is it titled in the name of the trust? The answers are yes, no, I don't know, or not applicable. Please take the next 15 seconds to make your selection, and then we will share the results. Okay, it looks like most of you have responded. And okay, we're going to go ahead and stop the poll and share the results. And it looks like most of you have said yes.
Well, that's great. We'll start with our first example. So remember, Judy has passed away, and this is Trevor coming in, her son, and he meets with us. And here's the first problem. The home is in Judy's name alone. It was bought after Judy's husband died, obviously, but before Judy died. And Judy never put this property into her trust. And how do you put real estate into a trust? Remember, I said you sign a deed, and you transfer the property from your name to, Judy would have transferred it from Judy, an individual, to Judy, trustee of Judy's trust. That's a deed. That's a piece of paper that is a writing. In California, it must be acknowledged before a notary public. That's also called notarization. And then it gets recorded at the county recorder's office where the property is located. Because the property is in Judy's name and Judy's not here because she's passed away, she's not here to transfer the property into her trust, and her son can't do it. Now, even if her son had a durable power of attorney, that durable power of attorney that Judy would have signed dies with Judy. So when a person creates a durable power of attorney and then they die, you can't use that once they passed away. And a $600,000 home, the probate fees are $24,000 in California. These are very high fees. I want you to think about that. $24,000. This is a very labor-intensive court process that probate lasts about a year. And probate is designed to transfer assets from a person who's passed away to the heirs if they haven't done a trust, right? So that's what probate's for. And by the way, Jen, if this house had a $599,000 mortgage and was worth $600,000, the probate fees are, guess what? They're still $24,000. So you don't get a discount if there's debt on the property. So what we would have counseled Judy, were she alive, we would have said, Judy, you need to do a deed and transfer that property to the trust. Our firm would have handled that. And most firms would charge a few $100s for transferring that property to the living trust. And that cost Trevor and the family, not only did it cost him $24,000, but about a year-long process of probate. We also recommend that someone in Judy's situation, check in annually with their lawyer, or at least check in annually to make sure these assets are properly titled. And for a lot of people, they don't know if it's properly titled unless you talk to a lawyer. So Judy also had a rental property. And unfortunately, this rental property was also in Judy's name alone. It was in the trust. So back in the day, it was in the trust, and then Judy went out to refinance the property. And what happens oftentimes when you refinance property that's in a living trust is the bank and the title company and the escrow, they'll say, look, we don't want to deal with this trust. We don't want to have to, this thing's like 100 pages long. We don't want to have to read it. This is a pain in the neck. So what we're going to tell you to do, Judy, is take this property out of your trust and put it in your own name, and then get the loan. And then once that deal's done, they might tell Judy, hey, you need to put this back in the trust. They might not. But in this case, Judy did not put it back in the trust. And the value is $900,000. And the probate fees are a percentage of the assets. And that's another $40,000. So we have a running tally here of $64,000. So what would the solution have been? The solution would have been Judy checking on the title. Lawyers do this. A competent expert lawyer has access to property records. So we could easily determine if the property were in Judy's name or in the name of her trust. We do this a lot for clients. They say, oh yeah, we took the property out, refinanced it, and then we do a deed and transfer that property back to the trust. The third example is Judy never putting her accounts, her bank accounts, her checking and savings accounts into the trust. And she had about $90,000, and you can see the probate fees are $3,600. And this is kind of an interesting one because it used to be, I've been practicing law for 25 years, 25 years in November. And 25 years ago, I started doing estate planning when I was 25 years old. And one of my first clients came in, he says, Jim, I have socks older than you. But here I was at the tender age of 25 doing estate planning. And at that time, we typically told clients not to put the checking account into the living trust. Now, the reason is people would go grocery shopping. And Jen, you probably remember this. You used to write a check I don't know. Does anyone write checks anymore? I don't know. Right? So that's not as much of an issue anymore, but it used to be if you had the name of your trust on a check, it would be really hard to go grocery shopping. So we typically canceled people. You don't need to put that in your trust. You should have your savings account in the trust, but not your checking. So now that, the world's changed 25 years later. So if your lawyer has told you, first of all, if you have a lawyer, obviously you need to talk to your lawyer, but if your lawyer's told you, hey, don't put the account in the trust, that's how it used to be. So if that advice might be a little bit older. So we do have issues with credit unions. I'm not picking on credit unions, but credit unions, the way they're structured, for those of you who have a credit union, is you typically have a member number and then sub accounts. And sometimes if you try and put a credit union account into a living trust, you can hit some speed bumps. They typically have workarounds, but that's an issue that we see. Many lawyers actually still tell clients, hey, you don't have to put this $90,000 in the bank, because actually you can leave $150,000, right? So you can have assets of up to $150,000, and those can pass by affidavit, not probate. So in order to even start a probate, you have to have real estate or more than $150,000 in assets. So, if you have $90,000 in the bank, is this necessarily going to cause a probate? No, but it does, because remember, Judy also had 2 pieces of property that were outside of her trust.
Jim, we have a question coming in from an attendee named Matt, and he is asking, could Judy have added her son to the banking account or given the property to him?
Oh, let's think about this. Let's say Judy put Trevor on there, on the bank account. What can Trevor do? Well, he can access all the money. He can spend it. So that's a little risky. What if Trevor's married and then his spouse decides that the spouse doesn't want to be married anymore? That's called divorce. Whose money is that? Is that mom's? Is it Judy's? Is it Trevor's? So we typically don't recommend that mom add son to the account, because that can be risky. And a living trust is better, because a living trust serves similar functions, but provides mom with superior protection if Trevor goes off the rails or gets a divorce. So on bank accounts, this, again, something you should be checking. It's pretty easy to determine if a bank account's in your trust, because you get a statement every month. Now, sometimes the statements will show your trust, and sometimes those records will be at the bank and it'll still be in your name individually.
Actually, we just got another question in, and Jill is asking, what should I do with my credit union accounts?
Yeah, so number one, talk to the credit union, but sometimes they will, if you request a sub-account under the main member account held in the name of the trust, and keep the balance in the main member account at the minimum, so maybe $5 in the main member account, and then your sub-account is a trust, that's where you put most of your money, that is a workaround. So, but definitely you're going to want to talk, actually talk to the manager of the credit union, because they typically have more training on this. But great question. So Judy had life insurance, and Judy listed Judy's children as the beneficiaries. Now here, it's good that she had life insurance, and it's good that her beneficiary designation was aligned with her estate plan, because she is leaving, I didn't tell you this, but she's leaving her estate to her children equally. Here's the problem. When you inherit life insurance, when you're the beneficiary and you get the money, that's your money. And that is stuffed into your pockets. And this is not common, it is not frequent, but it does happen. Sometimes beneficiaries, when Judy passes away, sometimes a beneficiary will call in and say, Jim, I'm in the middle of bankruptcy and I don't want this money. Is there anything I can do to avoid turning this money over to the trustee in bankruptcy? So the way bankruptcy works is you don't have control over anything anymore. The court appoints a trustee who takes control of everything, including your inheritance. And there is a way to protect it. And so what we would recommend to Judy in this case is that she leave her living trust the beneficiary of her life insurance policy. And that way, the way Judy set up her estate plan, she set it up in a way where the inheritance that she was leaving to her children was protected from creditors, predators, and divorce. So Judy, instead of just leaving it to her kids, what we say outright, so here, kids, when I die, I'm going to stuff this money into your pockets. Instead of stuffing the money into the pockets, we have some added protection built around the inheritance. And so that money, that $400,000, we chalk that up as a lost opportunity. Let's say the money just goes out to creditors or divorce and it's gone. Another issue that's come up, there are millions, tens of millions of Americans on disability that are people who have disabilities, and they are on the SSI program, which is a supplemental security income program. That is what is called a needs-based program. So if you have a loved one with special needs, and oftentimes these are, their children, they might be other family members, they might be grandchildren, great-grandchildren, you typically can't leave the money to those people, because if they get the money, then they get booted off their needs-based public assistance benefits. And so what we can do with the life insurance in this case is leave it to the living trust. And then when Judy dies and that money's paid out from the life insurance, there's what we call a special needs trust set up after Judy passes away that takes care of loved ones with special needs or who are on SSI. There's another program called SSDI, which is Social Security Disability Income, that is not needs-based. So it's a little bit different.
We have a question from John, and he is asking, does the beneficiary question also apply to annuities, which we're going to be talking about?
John, great question. The short answer is yes, but the advice is different. And we have an example that we're going to be getting to in a couple of minutes. Small business interest. Judy's late husband had a remnant of a small business, and the company records did not show that the stock in the corporation, or if you have an LLC, somebody sent us a question before we got started today saying, hey, what about LLCs? Businesses can be organized as corporations, partnerships, or LLCs, and all of these have documents that prove your ownership. So when my son was born, who's now 23, when he was born, a friend of mine says, oh, you need to buy some shares in Disney. I think I bought one share. It's up to 15. That share shows that I'm the owner of a few shares of Disney stock. That's a stock certificate. So in this case, Judy's late husband had a corporation. It's not Disney, right? It's a lot smaller, but it also has share certificates. So corporations typically have share certificates. Partnerships have partnership units oftentimes, or partnership shares, and LLCs can have membership units or shares or certificates. And so whatever you call it, Judy should have retitled those certificates in the name of the living trust. Okay, so that would have solved the problem. And again, $500,000, that's more probate fees. And it's a big delay, and having a business going through probate is a real catastrophe. So now we get to talk about annuities. This is fantastic.
Actually, we're going to go back to Actually, let's see. Well, there's so many great questions coming in, and we are going to get to most of them at the end. But Diane asked, don't you want your life insurance beneficiary to have immediate access to the funds so they can pay any bills while they wait for the trust to complete?
Yeah, great question. Yes, and most living trusts that I see, well, most well-written living trusts provide for immediate access to funds to pay expenses. So you're going to have a delay. You typically can't collect a policy of life insurance until you have a death certificate, and that can take a while. Now, if you pass away in a hospital, it's a shorter period of time. If you're under hospice, it's a shorter period of time. If you pass away and you're not under hospice and it didn't happen in a hospital, that can be delayed for a few weeks. So you're not going to get that life insurance money for a few weeks. So there's also another case years ago where the one company in the United States that printed the paper that made death certificates went out of business. And we went for a few months, I think, without being able to get death certificates. Kind of a weird, like, are you kidding me? There's only one company in the United States that makes paper to print death certificates. So if you leave it to the individual, it's not protected. If you leave it to the trust, it is. And if the issue is immediate access to pay bills, you still have that functionality with a living trust. Annuities. Well, let me explain to you what an annuity is. An annuity in this case is Judy giving $100,000 to an insurance company, and she never took any withdrawals. She never took any distributions. And the insurance company held on to that money for a very long time. In fact, they held on to it for so long that that $100,000 grew to $500,000. So $400,000 gain. If Judy would have cashed that annuity out, she would have been subject to that $400,000 gain being taxed as ordinary income. And when she dies, her beneficiaries also get stuck with that. So this is a little bit different actually than, if I buy something for $100,000 and it goes up to $500,000 and then I die and my kids inherit it, that is going to get what's called a step up in basis, right? That's assuming I own it individually and I die. It gets what's called a step up in basis, meaning my kids can sell that thing I paid $100,000 for $500,000 and not pay any tax. Now that's a really big deal. That does not apply to annuities. That does not apply. And what we're talking about here specifically are non-qualified annuities. These are annuities that are not in an ERISA plan. These are, which is 1974 legislation that enacted 401ks and IRAs and all that stuff. These are annuities that are not in your IRA or your 401k or 403b or TSA. So what happens? What can we do? Well, one mistake that we see is a blanket naming of the trust as a beneficiary. And here's the problem with that, is that money's all going to come out in 1 year. Boom. That $400,000 is going to be taxed. It's either going to be taxed at the trust rate level, which is higher, or sometimes it's taxed on the individual rates if you do the trust administration properly. But there's also a third avenue. And there is a method of inheriting an annuity where you don't take all the money out at once, but you take that first $100,000 out and you don't pay taxes on it. And then you can stretch out that $400,000 gain over the recipient's lifetime. That only works if you name individuals as beneficiaries of the annuity. So sometimes it's appropriate to name a trust the beneficiary of an annuity, and sometimes it's appropriate to name individuals the beneficiary of the annuity. But a lot of mindfulness has to be, you got to think about this, and you really need to meet with not only the accountant, but the lawyer and the financial advisor, the three of them, kind of like a three-legged stool, because this is a big potential tax hit, and we're in California. And if you add think about adding $400,000 to your personal income. I mean, it's good, right? Because you're getting the income, but gosh, just think about the taxes. I mean, it's probably 50% by the time you add up everything, right? State and federal, and it's quite a big number. So what should Judy have done? Well, Judy should have met with her financial advisor, accountant, and attorney and considered taking her non-qualified annuity and doing appropriate planning so that her children could defer the payment of the income tax on the $400,000 gain after she died. Now, that's a lot to throw at you guys, and if you're like, wow, my head is spinning, I don't really understand what this lawyer's talking about, on this webinar, just know if you have an annuity, that's something that you really do need some expert advice on. Otherwise, you might be paying too much in taxes, or your loved ones will. Okay, brokerage accounts. Judy did not put her brokerage account into her living trust. And so that's $300,000. And now that the probate fees are now up to $99,000. This is a running tally of probate fees. They're up to $99,600 now. And the probate fees associated with the $300,000 brokerage account are $12,000. That's a lot of money. And a year. You got to wait. So what should Judy have done? Well, Judy should have put her brokerage account into the name of the trust. Now, that sounds really easy, but that means, who's in charge of this, really? Think about this. Judy? Judy does, look, this is complicated stuff. It's important stuff. And for me to just simply tell Judy, hey, Judy, go to your brokerage, your advisor, and put your account in the trust, she's going to go, I don't really even understand what he just said. So what should have happened is written communication, a phone call, it's a yes and, email, whatever it is, with the brokerage firm, stating clearly how title should be held. And in this case, Judy, trustee of Judy's trust. Some common problems we see is the brokers actually forget to put the accounts into the trust. And bear in mind, if you're a financial advisor or a stockbroker, you are trained to what? Manage money, right? Pick stocks. You're not trained to pay attention to title. And typically this is an administrative function that is viewed as a lower level, less important function for the broker. And this oftentimes just kind of falls through the cracks, frankly. Another thing that happens is brokers change advisors. They go from XYZ firm to ABC firm, right? This happens quite a bit. So if you're a successful financial advisor out there in the ether, you know what I'm talking about. You're probably getting solicited frequently from other brokerage houses. And brokers do move. They also change, this is for in the independent financial advisory space, they will change from one place where the assets are housed to another one. So for example, you may have an independent financial advisor who uses a company. I suppose I can name names. Charles Schwab is one that does it, right? So an independent financial advisor is not an employee of Charles Schwab, but that's where your investments are held. Well, if they go from Charles Schwab to TD Ameritrade, they're going to a different company. They have to repaper, they have to retitle all those assets. Just think about that. If you have 100 clients with 100 different trusts, that takes a lot of time and it's a lot of work. So folks, you really need to pay attention to this. And I think sometimes there is confusion because brokers don't know, well, does this account go into the trust or not? Is it an IRA, an individual retirement account? If it's an individual retirement account, it's not going to go into the trust. We'll talk about those in a little bit. So put your brokerage account into the living trust. And this is where an annual review is very important. So what we typically do with clients is they will come in and bring all your statements. We can look at the statement, and from the statement, we can typically determine whether the account is in the name of the trust or not. Sometimes it is, sometimes it isn't. If your broker changed houses, it might have come out of the trust. If they're in the independent space and they go from Charles Schwab to TD Ameritrade, it may kind of leak out and not stay in the trust. All right, 401ks, IRAs. Here's the problem. Judy named her children beneficiaries of her, she actually rolled her 401k over to an IRA. She has named her children individually as beneficiaries of the IRA. Some lawyers will suggest that you name the living trust as the beneficiary, and we're going to go through why that is probably not a good idea in the vast majority of cases. But something that, which is interesting here, this lost opportunity of 2.7 million. If her 401k is $300,000, if her IRA is $300,000, how is that 2.7 million? Well, as you know, for those of you with IRAs, when you reach 70 and a half, that's your required beginning date. You have to take money out of your IRA whether you want to or not. It's called the required minimum distribution. It's required, meaning it's mandatory. You have to do it. If you don't do it, you get a penalty. So you reach 70 and a half, you have to start taking out of your IRA. Can you take all of the money out of your IRA? Absolutely. Would you? No way, because you pay tax, right? Typically, unless it's a Roth, you're going to pay tax on the money coming out of your IRA. Well, here's what happens when you die. When Judy dies and her kids inherit the IRA, 87% of the time, and this is real data, 87% of the time, the kids take all the money out within 1 year. 87% of the time, all the money out within 1 year. And there was a question earlier on, it's of, hey, what about life insurance? Maybe that can be used to pay expenses. Maybe people are taking money out of the IRA to pay expenses. Who knows, right? Maybe they're taking it out to pay off the Mercedes or remodel the kitchen. Who knows? Maybe it's the spouse of the kid who's inheriting. This is finally, my in-laws are finally gone. Now I can divorce this person. But before I do that, I'm going to make sure that they deposit their inheritance into our joint account, right? So 87% of the time, the money comes out all at once. Here is the problem with that. There's presently an ability for a person when they inherit an IRA to not take that money out all at once, but to take it out over their life expectancy, meaning if you're 50 and you inherit an IRA, you can take it out over about a 33-year period. Well, the advantage to that is if you inherit 100,000, let's say Trevor inherits 100,000 and he's 50, that 100,000 grows to 110,000. That first year, you're taking 3,000 out, right? So you have 107 left over. So 107's more than 100, and it's kind of has a snowball effect. And the next year, you take out 3,100, and the thing's grown to 114,000. So what happens is over time, if you do this right, folks, if your kids do this right, which they only do it right 13% of the time because people don't know, if you do it right, that 100,000 or that 300,000 can 10x, can be 10 times the money that's 10 times the value it started at when Judy died. When you look at that over that 30-year period, that's a 10x multiplier. This is a huge wealth generator for families, and many people don't know about this. Here's the problem. People don't know the rules. If you have your own IRA, there's a rule that says you can withdraw money from institution A and deposit the money with institution B within a 60-day window. And that's not treated as a distribution. That rule does not apply if you inherit an IRA, for an inherited IRA. There is also no creditor protection for an inherited IRA. What do I mean by that? Well, let's say Judy leaves her IRA to her kids, Trevor, and he's responsible. And Trevor says, okay, I'm going to take my 100,000 because I'm one of 3 kids, and I'm going to only take out the minimum distribution. It's called a stretch IRA. So if you Google stretch IRA, you can see it. I'm going to stretch this money out over my lifetime. Great. Well, he gets a divorce. Is that separate property or community property? Well, there's going to be an argument both ways. If he goes into bankruptcy, no creditor protection. If he gets sued, there is no way to protect an inherited IRA because you can't move it around. It's just in your name. You're a beneficiary of an inherited IRA, and any judgment creditor can yank all that money out of your account. So what's the best way to do it? We use something called an IRA legacy trust. What's that? Well, it's kind of like, Jennifer, I see a lot of Teslas. We're in California. I see a lot of Teslas around. A Tesla, I've heard, is like an electric Mercedes. So when Teslas first came out, they said a Tesla is like an electric Mercedes. It's not a Mercedes, but it's a nice car, and it's powered by electricity. Okay, it's not a Mercedes. Like in the same vein, the IRA Legacy Trust, it's like a living trust for your IRA, but it is not a living trust. It's a special purpose trust. We would have counseled Judy to consider leaving her IRA to an IRA Legacy Trust. And that guarantees, right, that at least someone's going to hit a speed bump somewhere and say, there's this trust. I don't know what to do. Okay, well, wait, don't do anything. Because a lot of the stuff with IRAs, once you do it, you can't undo it. It's unringing the bell. It's pulling the cream out of the coffee. You're not going to be able to undo it. And so that IRA legacy trust effectuates a stretch, creates a huge amount of wealth for the family, and also creates a plan for the inherited IRA, because $3 million is a lot of money. You want to plan for that money and you want to protect it.
So Jim, Judy, the real Judy from the audience is actually asking, isn't the legislature considering ending stretch options?
Yeah, so that's the Secure Act that passed the House of Representatives by, I don't know, 400 something to 3. Everyone thought this thing was going to go sail right through. And in fact, what's happened is it's stopped in the Senate, and there are 3 senators who don't like it. And people have been talking about this all summer. And one of the things they're starting to realize is, hey, under the new act, they're cutting down that time period from your lifetime, which is up to 85 years, if you're 0, right? If you're a newborn and inherit an IRA, they're going to cut that down to either 5 or 10 years. It will not eliminate the need for an IRA legacy trust. It will actually make the planning more complex, and it will probably mean that you'll have to do some planning, or should consider some planning, during your lifetime. And all it is looking at the differentials between income tax rates. It actually gets a lot more complicated with the Secure Act passing. But that's a great question. That's on the horizon. I actually did a blog post on LinkedIn that said this is not a guaranteed passage, and I was reposting an article from an online news organization, a reputable, not a fake news organization, but a real one, right? But that is not guaranteed to pass. So if it does pass, it's just, we have these young attorneys that sometimes will join our firm, and they'll say, Jim, aren't you worried about the law changing? I said, are you kidding? Every time the law changes, it just keeps us busier, which I know you probably don't want to hear that if you're a consumer, if you're on the client side of it. But the fact is, the tax laws do change. You need to pay attention to it, because this is really important stuff. I think we can all agree this is really important. That's why you're listening. All right, inherited IRA from a late spouse. So what we did here with Judy is, Judy wanted to leave this to the grandkids. And what happens if you name a grandchild? Let's say you name a 2-year-old grandchild as a beneficiary of an IRA. What happens? Well, you have to go through a guardianship, even if the kid has parents, because once you in California, over 5,000, you got to have a court guardianship. And once that kid turns 18, they can yank all the money out of the IRA. They can take it all. So here, Judy wanted to leave her IRA to her grandkids. And had she left her $600,000 IRA to her grandkids in an IRA legacy trust, that would have been $38 million in payouts to the grandkids. It's because it's being stretched out literally over like an 80-year period, 80-year period. This is crazy. I think, the government is probably looking at this. Legislators are looking at this saying, wow, this, we can't let this happen, right? We got to get that money quicker. But this is the law right now. Also, under the Secure Act, by the way, it did have an exclusion for people under the age of 18. Now, I don't know if it's just kids or grandkids, but it may mean that going forward, if this is enacted or passed and signed by the president, it may be that people will be doing these inherited IRAs for grandkids, right? So she didn't do it. She left the $600,000 to the grandchildren individually, and then it's just a big pain in the neck for everyone. So what would the solution have been? Consider an IRA legacy trust for the grandkids. And pay attention to this. Look at it every year. Make sure, one thing that we recommend to clients is that an inquiry be made to each institution every year, because an IRA passes by beneficiary designation, and it doesn't matter what you think the beneficiary designation is. It doesn't matter what your records say. What matters is at the institution what they can find when a person passes away. So when Judy passes away, they don't really care what our records say when it comes to IRAs. They're going to look at their own institutional records. And I will tell you, we had one instance, when the banking crisis happened in 2008, one institution went out of business, taken over by another one. That institution that took over the defunct institution could not find the beneficiary designation and said kind of flippantly, well, we didn't get all the paperwork over here. Your client should have contacted us and verified. And I thought, man, I don't like that. But that's, this is important stuff, guys. You need to ping. Either you do it, your lawyer does it, somebody has to do it, but you need to make an inquiry and find out, hey, who's going to get this when Judy passes away? So by Judy not, and again, remember we started this, we said Judy had a great living trust, right? She had a great living trust. She had a great plan. It wasn't funded. Her assets weren't aligned. The lost opportunity, probate fees of $123,000, lost opportunity over $40 million. So I will just say one very quick thing. 25 years ago, people were a lot less wealthy. I think people have a lot more wealth now than they did 25 years ago. And I'm sure you've heard we're facing the biggest transfer of wealth in human history, and it's happening now. This is too important to pass up. You really need to pay attention to this.
Okay, so we are about to launch our last poll. The question is, if you have a living trust or estate plan, have you ever reviewed the asset alignment with your attorney? Answers are yes, no, I don't know, or not applicable. Go ahead and take the next few seconds to answer the question, and then we will share the results. Okay, they're still coming in fast and furious. A few more seconds, and then we're going to close the poll. Okay, we're going to share the results, and it looks like most of you, well, about even yes and no, which is good and bad, right?
Well, good. I mean, for those of you who've done it, that's fantastic. And for those of you who haven't, I think you can see the benefit in making sure that your assets are aligned with your estate plan. Obviously, you've taken the time to listen here. It's important and very important stuff. So what are the next steps? Okay. This is a punch list. You really need to look at your estate plan again. I know it's written in legalese, probably, hopefully, written in legalese, not exactly normal English, but make sure that you understand what it says. That's very, very important. Blow the dust off the thing, pull it out of the safe, wherever you keep it, under the refrigerator. It's where my grandparents used to keep all their important papers under the refrigerator. And also look at how each asset should be aligned. Okay, so how should these assets, who should the beneficiary be? Again, you're probably gonna have to work with more than one professional on that. Secondly, take all the steps you need to align your assets. This may mean getting in the car, going to the bank, going to the brokerage account, letters to companies, all right? It sounds like a lot of homework. It is, but it's important. Double check your alignment. You got to circle back with these institutions and verify, is this in the trust? Is this the beneficiary? The other thing that happens, Jennifer, is that people die out of order. So many of our clients come in and for a review, and we ask, why are you here? They say, well, unfortunately, one of our children passed away. So that's what I mean by dying out of order. If someone passes away, that is an indicator that you need to revisit your estate plan, because if you have 3 kids on an IRA or a life insurance policy or whatever it is, or an annuity, and one dies, do the remaining 2 people get that account, or does it go to that 3rd child's children? Each institution is different, so you need to pay attention to that. And double check it every year. So you got to check it in the first year, and I would highly recommend this is something you check every year. Now, for most people, they're frankly not that diligent. This sounds like a lot of homework. Our firm, we offer something called the Legacy Care Program. And what this does is we do that homework as much as we can for you. Sometimes, sadly, you do have to get in your car and go to the bank. Although, my dad went to a big, huge bank that will remain anonymous. And he said there was this huge room and a line of like 10 teller stations, but only one teller. And there was this long line of people, and my dad's 76, and he goes, Jim, they were all my age. I guess they don't like to do online banking, or at least those people didn't. But you may still have to go to the bank, is what I'm getting at. But the rest of the alignment, tracking, what do I mean by tracking? Literally putting it on a spreadsheet, tracking it. What do you have? Because if you get sick or pass away, people aren't going to know. And it's good to keep a running tally.
Today's webinar. Just a reminder that you will receive a follow-up email within the next 48 hours with the link to view a recording of today's webinar. And again, if we didn't get a chance to answer your questions, we are going to follow up with you afterwards. On behalf of Cunningham Legal, thank you for joining us today.